hear ye, hear ye. All manner of persons having anything to bring before the Honorable Justices of the Supreme Court of the State of Delaware will now draw near and give their attendance. The court is now open. God save the state and the Honorable Court. Please be seated.
Welcome, everyone. Good morning. Thank you, Capitol Police, for being here today. Introductions.
Good morning, Your Honors. Garrett Moritz from Ross Aronstam on behalf of Appellant, Elon Musk. Pleased to introduce Evan Chesler of Cravath, Swain & Moore. With the court's permission, Mr. Chesler will be presenting the argument for Mr. Musk today. Thank you.
Thank you very much and welcome.
Thank you, Your Honor.
Good morning, Your Honors. Catherine Gall from Ashby & Geddes on behalf of the nominal defendant, Tesla, Inc.
Mr. Hanrahan, good morning.
Good morning. May it please the court. This appeal challenges a further erosion of Delaware's entire fairness standard. As the court below observed, Corwin and MFW substantially narrowed entire fairness by providing two new pathways to business judgment deference. In this case, the Court of Chancery substantially weakened the entire fairness standard itself. The trial court said its opinion was a parable which taught that Musk might have avoided some defense costs had there been a fair process. Practitioners have recognized already, however, that the real lessons from the opinion below are that independent committees are unnecessary, that to establish unfair dealing, stockholders must prove the controller coerced a conflicted board and prevented it from meaningfully vetting a transaction, and that price trumps unfair dealing. The deterrent effect of entire fairness will be lost as headstrong CEOs and controllers like Musk will resist independent committees in order to retain the ability to inject themselves into the process. Reversal is required on four grounds. First, the trial court misapplied the legal standard by holding that fair price establishes entire fairness despite unfair process. Second, it committed legal error by concluding that SolarCity's June 21, 2016 stock price established fair price when under Aruba and Jordan, market price is not an appropriate measure of value when subsequent events render it unreliable. Third, the factual findings concerning the board's unexplained failure to establish an independent committee and Musk's pervasive and undisclosed interference in the process require a legal conclusion of unfair dealing. Fourth, the uninformed stockholder vote was evidence of unfair dealing, not as the court below erroneously held, evidence of fair price. As in Weinberger, this court should hold that the trial court's findings establish unfair dealing, should reverse the finding of fair price, and remand the case for a re-examination of the valuation evidence and a determination of remedy. The trial court misapplied entire fairness because it essentially wrote fair dealing out of the standard, holding that the linchpin of entire fairness is fair price and all roads lead to fair price. The trial court's price-centric approach derived from Weinberger's comment that price may, not shall, be the preponderant, not sole, consideration in a non-fraudulent transaction. Weinberger did not say fair price trumps unfair dealing or that all roads lead to fair price. Furthermore, as Weinberger's discussion at pages 703 and 713 and 14 shows, the statement that price may be preponderant was in the context of whether appraisal, where price is the only issue, should be the exclusive remedy in most cash-out mergers, which was a hot issue at the time. Subsequent opinions of this court held appraisal is not the exclusive remedy in a Section 251 merger. Weinberger at page 714 indicated that the fair price prong does not limit equity's power to grant relief and that fair price may not be an adequate remedy in cases involving misrepresentation or self-dealing. As CDV Technicolor recognized, under Weinberger, entire fairness requires proving both fair dealing and fair price, and there may be legally cognizable injury even if the price is fair. Thus, in a self-interested transaction or where there's an uninformed vote, fair price is not the exclusive or even the preponderant determinant of entire fairness. The trial court should have determined that there was unfair dealing and considered fair price and entire fairness in that context. Instead, its opinion essentially relegates stockholders to an appraisal remedy. Unless you prove unfair price, there is no remedy despite unfair dealing. This contradicts this court's teaching in Thorpe and the outcome of Weinberger, where on remand, the court recognized that defendants had flunked the fairness test because of unfair dealing and awarded $1 per share, even without a fair price finding, because equity will not suffer a wrong without a remedy. Now, cases like Nine Systems and Oliver, the court below cited as supporting fair price as the ultimate determinant of entire fairness, actually held that there was a lack of entire fairness because of unfair dealing, but concluded the unfair process could not have affected price because the common stock in those cases had no value. Nine Systems held that fair price does not ameliorate unfair process, and that Trados did not stand for the proposition that a finding of fair price forecloses a conclusion that the transaction was not entirely fair. And in that was another case where the common stock had no value. Because the Court of Chancery made fair price the foundation of its opinion, if its fair price finding was wrong, the whole house of cards comes down. Fair price is an issue of law. Jardin and DFC recognize that fair value is a law-created valuation method, not a purely economic determination. Fair price in an entire fairness analysis is equivalent to fair value in the appraisal context and is likewise a jurisprudential construct.
Mr. Hanrahan, let's assume the price was fair. What would you have this court order the Court of Chancery do on remand?
Well, I think the court should find unfair dealing. The Court of Chancery discussed unfair dealing at length, but then essentially said, well, since I find the price was fair, it really doesn't matter. I think this court, as the court did in Weinberger, should say that the findings of the Court of Chancery mandate a conclusion of unfair dealing, and even if the court were to conclude that the price was fair, there should be a remand for the court below to reconsider entire fairness and to determine what remedy should be given, even if, as has happened in certain cases, there was simply unfair dealing but a conclusion of unfair price.
Mr. Hanrahan, I have a question about the role of the trial court in an entire fairness case versus an appraisal case. You mentioned some appraisal cases. The Vice Chancellor at page 105 of his opinion says, in a plenary breach of fiduciary duty action, the court's function when assessing fair value is not to conduct its own appraisal, but to land where the preponderance of credible and competent evidence of fair value takes it. Isn't that a correct statement of law? And where does that put you when your entire valuation case was based on insolvency, where the trial court found that totally incredible and your expert disavowed any other valuation methodology? Doesn't that leave you with nothing on your side of the fair value ledger?
I don't think so, Your Honor, because I think what the court below did was say, oh, if you didn't prove insolvency, then the price is fair. Our expert and the other side's expert did provide DCF analyses. In both instances, they said other methods, in their view, were more appropriate. Our expert said a liquidation analysis would be more appropriate. The Musk expert said that market price was more appropriate. But there's evidence in the record that in terms of DCFs, and indeed the court then goes on to rely on Evercore's fairness opinion, which was based on DCF analysis. So you're in a situation where the market price, as I'll get to, is not a proper indicator of value. The deal price isn't a indicator of value because you have a self-interested transaction. And so the court should have gone on to consider the other evidence, and it should not have said, with respect to the DCFs done by the experts, that DCF is not an appropriate valuation method.
But that's what your expert said.
Well, again, the court disagreed with our expert in terms of whether SolarCity was insolvent and it should be liquidation. But our expert said, well, if you're going to value it as a going concern, I did a DCF. And the other side's expert said market price is most appropriate, but he also did a DCF. And then the court turned around and without any explanation rejected those DCFs, but then relied on SolarCity's cash flows and the Evercore opinion, where Evercore testified that market value was not appropriate because there was information regarding SolarCity's liquidity that wasn't known to the public as of June 21. And they said DCF was a better method. So the court had a record in front of it, and I think the court's job there was to evaluate all the evidence, not be inconsistent in terms of saying that DCF is relevant when Evercore does it, but not relevant when others do it. And I don't think that the case ought to turn on the fact that the expert took a view that the court disagreed with. In essence, the court put the burden on us and said, well, in order to establish unfair price, you have to succeed on your insolvency theory. We didn't succeed on that. But there was an alternative method, and the court ought to try to find the correct result with the evidence that was before it. So I don't think it was proper to just exclude the DCFs, particularly not when you exclude them as some DCFs, but then rely on a DCF essentially later in the opinion. In the course of about 5 or 8 pages of the opinion, the court says one thing and then does something else just a few pages later.
Mr. Hanrahan, I'd like to take you back to your unfair dealing claim. You frame the argument in your brief as the trial court erring by failing to determine that Musk had not met his burden to prove fair dealing. I have a two-part question. Are you suggesting that we should independently weigh the evidence and determine whether it preponderates in plaintiff's favor on the issue of fair dealing? And if relatedly, how does that fit in with your criticism of the trial court for bifurcating the entire fairness analysis?
Well, as sometimes happens, this court looks at the application of the standard. The trial court made a series of factual findings. It found that there was no independent committee and there was no explanation by the directors for the lack of an independent committee. It further found that as a result of that, Musk was more involved in the process than a conflicted fiduciary should be. And the court made 10 specific findings of Musk's inappropriate involvement. And so what we're asking this court to do is to make the legal judgment that given the lower court's findings, that requires a legal conclusion that there was unfair dealing in this case. So the application of the legal standard is not a matter of discretion. The same is true in the fair price area. As Aruba and Jordan indicate, this court said, okay, you've got an economic aspect of it, but you also, the court has laid down rules as to how fair price should be determined. And one of those rules is that you cannot rely on market value if subsequent events have rendered that unreliable. And that's what happened here. And the proof of it was that even the Tesla board and Evercore concluded that things had changed at SolarCity. And that's why there was a renegotiation of the price. And yet the court below stuck with the June 21 so-called unaffected market price. So I think the key here is for this court to look at the legal issues with respect to the application of the standard, given the factual findings that the court below made.
But aren't you asking us to reweigh the evidence? Because the court did indicate that it balanced the process flaws in the overall analysis. For example, I'm looking at footnote 555. It is in a footnote. But nevertheless, the court says, with the Tesla board's deal process front of mind, after careful consideration for reasons just explained, Elon's compelling evidence on price fairness was ultimately persuasive, such that I conclude the acquisition was entirely fair. So the court is telling us it balanced, it was the ones sitting in front of the witnesses, and it balanced the evidence overall.
But I think when you get to the last part of the court's statement, ultimately what the court says is, well, I looked at the fair dealing evidence, but since I concluded that there was fair price, it really doesn't matter. And that, we think, is exactly the problem.
I'm sorry.
And I think furthermore, the burden was on Musk to prove fair dealing. The burden was not on the plaintiffs to prove that every step of the process was flawed.
Mr.
And
Hanrahan, can I just want to follow up on Justice Valahura's question, and mine is two-part also. Isn't it true, both from that statement that she had just read, that the Vice Chancellor did say, I am making a finding on fair dealing. There is fair dealing and fair process here. There are flaws. I've weighed the positives and negatives. Didn't he actually make that finding? Because it seemed earlier in your argument you said he never really made that finding. He skipped over it.
I don't believe he did. And I think if you look at the conclusion of his fair dealing discussion, he says, well, ultimately, it's a matter of fair price.
Okay,
and therefore, he never reaches a conclusion.
I get that. But let me ask one second follow-up question. Are there any specific factual findings that he has made, you've talked about the 10 weaknesses that he found, that you disagree with, or some of the strengths that he says factually were present?
Well, no, we're not challenging specific factual findings. What we're saying is when you have the lack of a special committee, you have a lack of an explanation for that, which is an important element of fair dealing, and you have specific instances of unfair dealing conduct that resulted from that, that requires a finding of unfair dealing.
Thank you.
I'd like to save the rest of my time for rebuttal. Thank you.
Thank you.
Mr. Chief Justice, and may it please the court. I'm Evan Chesler, and I represent Mr. Musk. The acquisition of SolarCity was a strategic objective of the company for 10 years before the transaction was completed, beginning as early as 2006. It created the first fully integrated alternative energy company in the country. In the lower court's words, the combination has allowed Tesla to become what it has for years told the market and its stockholders it strives to be. The court conducted 11 days of trial, heard from 19 witnesses, wrote the 131-page opinion, which is before you, made explicit credibility findings with respect to at least 10 of those witnesses, none of which is ever mentioned in the appellant's arguments. The finding that the transaction was entirely fair is in this court entitled to substantial deference. It was, as this court said in the Cinerama case, sufficiently supported by the record and is the product of an orderly and logical deductive process. The standard which the court applied was, as appellants acknowledged, entire fairness. The court assumed, but did not decide, three critical things. One, that Mr. Musk was a controlling stockholder. Two, that the board was conflicted. And three, that the vote of the stockholders did not entitle the company to the business judgment standard. On the burden of proof, the court said, I need not decide who has the burden of proof because the evidence favoring defense is that compelling. Now, what the appellants have done here, we submit, is to ignore whole swaths of this 131-page opinion. It is as if they haven't read it all. They say that the court below focused only on the process flaws. Well, they focus only on the process flaws. There are 10 pages of this opinion that discuss the strengths of the process, and there are additional pages in which he deals with each one of the flaws and explains why, in the court's judgment, that flaw does not render, either individually or in the aggregate, render the process unfair. And contrary to what counsel just said, the court explicitly finds that the process was in fact a fair process, separate and apart from finding that the price was fair. Indeed, the court says that under the direction of Ms. Denholm, the chair of the board, who was unbiased and led the process with integrity and ability, the process, he believed, showed that the board deferred to the interests of the Tesla stockholders and was therefore a fair process. The appellant says that the trial court relied almost exclusively on the June 21st unaffected market price. I'm going to come back to that point because that's just not so. As I'm sure this court is aware from looking at the opinion, there are 20 pages of analysis on the fair price issue. Only one of the elements that the court looked at was the unaffected market price. It looked at 7 or 8 or 9 other market factors, which I'll quickly review with the court. What I believe is happening here is that there's a conflation of findings of fact with conclusions of law in order to avoid the deference standard. In fact, the court's findings of fact are well documented. They are exactly what this court said in Cinerama, the result of a thoughtful process. And basically, the appellants seek reversal because they don't agree with the way the trial court marshaled and weighed the evidence.
Well, I'd like to stop you there as you're talking about deference. There seems to be a parting of the ways on this issue. I think you cite Cinerama, they cite Tremont, which does have language in it that says that the application of legal standards is subject to de novo review. You both go back to Levitt versus Bouvier, which doesn't contain that specific language. Could you address your friend's contention that this application of the legal standard entire fairness is a matter that we should review de novo?
Yes, Your Honor. Of course, legal standards are for this court to apply. Factual findings are entitled to deference. I don't believe you can separate the two. The legal conclusion was based upon a myriad of factual findings. This court, I submit to you, must find that the factual findings, notwithstanding the deference standard, are erroneous and cannot be relied upon as the basis for the legal conclusion. You cannot, I don't see how you can separate or disaggregate the findings that supported the legal conclusion from the legal conclusion itself. And I think that's what the import of the Delaware cases is, as it is in most jurisdictions. So the question before this court is, were the findings on which the court based its legal conclusions so erroneous that they are not entitled to deference in front of this court. And I do not see how that could possibly be the case here. This court, we talk about fair price, if I can just use that as an example for a moment. I tried this case. I was there. I saw the interaction between the trial court and Mr. Quintero. The trial court essentially pleaded with him to say, what other options are you giving me other than that this company was insolvent? Are you crediting any of these alternative? No, I'm not crediting them. This company was insolvent and they shouldn't have paid anything for it. And as the court said in its opinion, he swung for the stands and missed. They relied exclusively on that question. Now, unless this court, for example, on price, finds that that's a clearly erroneous finding, that the court reliance on the fact that Quintero only provided one theory and that theory was incredible on its face, I don't see how you can then get to a legal conclusion that says the price was unfair. And I don't see how, when the court below spent not only 10 pages on the strengths of the process, but went through every single alleged flaw and explained why that alleged flaw, in the court's opinion, did not render the process unfair either separately or in the aggregate, how you can disaggregate that from the legal conclusion that the process was fair. So I believe that they are interwoven. And what the court went on to say, I'm now on the question of process. This is at 127 of the opinion. In instances where there are process infirmities, the court is obliged to study fair price even more carefully. That's not bifurcation. That's not ignoring the process. That's looking at it exactly as the court said it would and was required to, which is holistically. It said, I have to look at process and price. There were some infirmities in the process. I'm weighing those. I'm evaluating those. I'm not only responding with what I believe the evidence showed with respect to the infirmities, but I'm also focusing on all the strengths that the process had, and where there are infirmities alleged, I'm going to look even more carefully at the price. It doesn't make price the exclusive basis for the entire fairness standard. That's not what the law is. That's not what the trial court did. What the trial court said was, notwithstanding the imperfections in the process, ultimately under the direction and influence of a disinterested decision maker, Ms. Denholm, I am satisfied that the Tesla fiduciaries place the interest of Tesla's stockholders ahead of their own. That is a commentary on process, not on price. So the suggestion that the court ignored the process issue or never made a conclusion or finding with respect to the process issue is simply not supported by the opinion. As I said, the court addressed every one of the flaws that had been raised by the appellants below, the bridge loan question, the timing of the transaction, Musk's communications with the bankers. He went through every single one of them at length and addressed every single one of them. He then spent 10 pages on the strengths. The timing of the transaction was when it was in the interest of the company, not when Mr. Musk wanted to do it. The approval of the stockholders, on which he relied less because of the allegations about disclosure issues, but nevertheless it was not irrelevant, and the trial court pointed to the stockholder vote. He talked about the use of independent top-tier advisors, the Wachtell firm and the Evercore bankers, that Mr. Musk and Mr. Gracias were recused from the votes, that as a result of the due diligence that was led by Ms. Denholm and the bankers, the price was lowered ultimately to a price below the low end of the range that was originally proposed. Exactly what you would expect to find in an arm's length transaction in which the board was doing its job. The court referred to multiple instances in which the board did not do what Mr. Musk wanted to do and instead did what they believed was in the interest of the stockholders. He focused on the robust public debate about the transaction, including a report by one of the preeminent proxy advisors that called it a bailout, all of which was known to the institutional shareholders when they overwhelmingly voted in favor of the transaction. And he emphasized the independence and qualifications of Ms. Denholm. The strategy here, the legal strategy for the appellant, seems to be to equate flaws with an ultimate finding of unfairness, rather than to understand that if there are issues such as the ones raised by the trial court, the proper result is that the entire fairness standard must be applied and not the business judgment rule. Now, counsel several times mentioned the lack of a special committee. In their opening brief, they seem to say that that alone requires a finding of unfairness. In their reply brief, they seem to have backpedaled to it's very important and in conjunction with other flaws should have resulted in unfairness. In fact, the absence of the committee is not in and of itself evidence of unfairness or a reason to find unfairness. It is a factor to be weighed under the entire fairness standard.
What is your best response to the argument your friends make and the amici make as well, that if this decision stands, the entire fairness standard is undermined, and availing oneself of the protect the MFW framework is sort of passé, not their words. I think there's a policy issue here that we need to confront, and I'd ask you to respond to that.
Yes, Your Honor, I will. My response to the policy issue is this. You cannot fail to evaluate the evidence that is put forward under the entire fairness standard, and if you do, then you've eviscerated the standard. The standard exists for a reason. If you're not entitled to business judgment review, and the court assumed we were not here, and therefore evaluated the evidence under entire fairness, then you must evaluate the evidence on the entire fairness standard appropriately, thoroughly, comprehensively, which is exactly what the trial court did. To find at the end that there was an entirely fair transaction is simply the appropriate application of the standard. We believe what the amici are arguing, what appellants are arguing is, if you find that the transaction was entirely fair in the absence of a special committee or in the presence of flaws, then you've undermined the standard. That doesn't make any sense. By applying the standard, you have emboldened the standard. You have given the standard muscularity. You have applied the law. It must be the case that entire fairness standards cases can be won by defendants, or else the standard is illusory. What happened here is we demonstrated to the trial court that this was an entirely fair transaction. And as he illustrated in 131 pages of analysis, the trial court simply explained why he agreed with that proposition. That doesn't undermine the standard. It demonstrates the vitality of the standard. So I profoundly disagree with what amici said, and I profoundly disagree with what appellants argue here.
How do you respond to their suggestion that the trial court placed too heavy reliance on June 21 stock price when at the same time the trial court had findings that there were at least a couple of buckets of information that the June 21 stock price didn't factor in, such as the liquidity concerns and the credit downgrades?
Right. Let me respond directly to that, Your Honor. Thank you for that question. First, it was one of 7 or 8 factors which the court considered. That is unaffected stock price. Only one. And I want to come back to the others in a moment. 2, both sides, experts agreed that this was an efficient market. There was no dispute about that. 3, every single major market commentator, every one of them, relied upon the same date contemporaneously at the time. The only dissent was Mr. Beach, who was the plaintiff's expert. Contrary to the plaintiff's contention, the market knew, and the evidence showed that the market knew, that SolarCity had reduced its projections for the megawatt installations going forward. That was prior to the time that the vote took place, and that's opinion 36, note 175, talks about the market's awareness of that, and they were well aware of the liquidity issues.
But as of June 21, how do you deal with the fact that, you know, from like an Aruba standpoint, that as of that point in time, there were at least a couple things that the stock price didn't factor in, according to the court?
Right. They all relate in one way or another to the liquidity question, the things that the court admitted were not known at the time. And what the court found, based upon the evidence and the testimony, was that they were a consequence of the offer that had been made. They were necessary consequences of the transaction. Once the company was in play, once it was publicly announced that there was a transaction, that had an effect upon the company's access to capital and debt markets. That is not what the unaffected market price cases deal with. Where it is a function of the transaction, you can't separate that from what the market knows. It's a necessary consequence of what the market knows. And the critical thing, Your Honor, is they all relate to liquidity, and as the court found, SolarCity never ran afoul of its liquidity covenants. It never breached its liquidity covenants. So all of the questions about whether there were liquidity concerns, which is what was alleged not to have been known at the time of the unaffected stock price, were things that never resulted in the covenants ever being breached. And as I said before, there are at least 7 other price-related variables that the court considered. If you discounted entirely the unaffected market price, It wouldn't change the fact that Mr. Quintero told the court that it was an insolvent company. That was the only credible evidence the court found that the plaintiffs offered for what the value of the stock should be.
Mr. Chesler, let me
Yes, sir.
just follow up on Justice Valahura's question. One other weakness, and I'd like you to just address the trial court's formulation of how he dealt with the Bank of America's downgrade. He said, well, look, if the bank doesn't much care, why would anyone else? Why would the market care?
Mm-hmm.
But isn't that really the same as placing it saying if the directors don't care or don't view it as being material, then an investor would not either, or one trying to determine the price of this stock?
I'm sorry, I don't want to interrupt.
No, that's fine.
I don't think so, Your Honor, and I don't think so for several reasons. First, as I said before, this all relates to the overarching issue of liquidity. The question is, what did the shareholders know and what should they know about the danger that this company was in fact so illiquid that it was going to default on its covenants, that it was such a credit risk that it couldn't maintain its business? It was publicly known what the covenants were. It was publicly known what the cash balances were and what the debt requirements were at every single quarter, each reported to the marketplace. And again, most importantly, it never defaulted on the liquidity covenants. So I believe you have to look at the court's conclusion about Bank of America increasing its obligation line to the company after it downgraded it in the context of the fact that the company did not ever default. Had the company, just hypothetically, had the company ultimately defaulted on its covenants, notwithstanding the fact that the banks extended them more credit after the downgrade, I think it would be a very different case, would be a very different
But
issue.
isn't the real question what the investor might see from the outside? Not that they didn't eventually default, but the fact that there is that greater risk when they are that close to the liquidity line.
And as I said, Your Honor, they had quarter after quarter of lowering balances publicly disclosed, quarter after quarter of what the debt obligations were, quarter after quarter of the financial condition. Nobody ever challenged the accuracy of those disclosures at all. And they had this Glass Lewis report which laid out in gory detail what they thought the future held, and that this company was going to default, that this was in fact a bailout of cousins by cousins, and that this was an illiquid company that should not in fact be worth the price that was paid. All of that was in the public domain before the stockholder vote. And the stockholders voted overwhelmingly in favor of the transaction.
Mr. Chesler, in the appraisal context, this court has suggested that the trial court should give some indication as to the weight it places on different valuation methodologies, DFC for one.
Mm-hmm.
Is there any requirement in the entire fairness context that the trial judge set forth a numerical range or indicate what weight it is placing on certain fair price metrics?
I don't think so, Your Honor. This is not an appraisal case. The body of law, as Your Honor's question suggests, is very different. The court's job here was to take the evidence that was presented by the parties and determine if he had assigned a burden of proof. I would say in the context of whether somebody proved or met their burden, but here he said it's unnecessary to do that because the evidence is so overwhelming. Look at the evidence that's presented and decide whether there was credible evidence of a fair price. I think it's very important to note when the court's discussing the Quintero strategy of swinging for the stands and missing, the court says there was no credible evidence provided to the court of what the plaintiff's fair price was. The insolvency position was incredible, and there was no alternative. I pressed for an alternative. I was not given one.
Well, I believe they point to one of your experts, Mr. Fischel's testimony as to the value on the date of closing as somehow being relevant. Do I have that wrong?
I think Professor Fischel gave several different options to the court. I think importantly, they claim that that's an apples and oranges comparison, but Professor Fischel also compared the price to the time of the contract, not at the time of closing, and showed the court that there was at most a modest 14% premium over the then market price, which was, he showed, consistent with a raft of other transactions that had been done.
Well,
The court's
on that point, so I'm clear on this, is that the date of contracting should determine fairness unless, because there's a contractual duty to to close at that price unless there's some excuse for closing.
I think in this case, Your Honor, they're both relevant because there was a ratio. The deal was done in terms of ratio of one stock to the other stock, and the result of market price changes in the interim was the company, Tesla, actually paid $500 million less for the company at the end of the day than it would have paid based upon the ratio at the time of the contract. It's not dispositive, but they're both relevant. The reality is how much of the company's money was paid for this company, and the answer was $2.1 billion, not $2.6, I think it was, because the ratio mechanism that the board chose to use worked in favor of Tesla during that interim period. So I think both data points are important.
How do you respond to Mr. Hanrahan's suggestion that there's some tension between the court's finding that the DCF analyses were not helpful, and yet as part of its 6 factors that it looked at in fair price and finding the price to be fair, it looked at SolarCity's current and future cash flows?
My answer is I think Mr. Hanrahan left one important fact out, which is the distinction between the contemporaneous discounted cash flow analyses that were done at the company and the made-for-litigation discounted cash flow analyses, which the court did not credit. That's the distinction. Both sides came in with after-the-fact experts who did discounted cash flow analyses. Mr. Quintero said, I did it, but don't rely upon it and don't pay any attention to it. Dr. Fischel did it and said, I'm giving it to you. I don't think these are particularly useful after the fact, but here it is if you want to consider it, because the other side did one. The court said, I'm not considering those. What the court considered was not the made-for-litigation DCFs, but the contemporaneous DCFs, which the company was actually using to conduct its business. Those, the court found, were relied upon by Evercore and were appropriate. By the way, Evercore did 7 separate valuation analyses, several of which were not DCF. I think 5 of them were DCF. The court said these were all important because they informed the fairness opinion that Evercore gave. Despite the attack on Evercore's credibility by the plaintiffs, the court found that they had done a very professional job, that they had not compromised their integrity in any way, and that those contemporaneous DCFs were appropriate for reliance by the court, as distinguished from made-for-litigation DCFs, which the court discounted. That's the distinction, I believe. So with respect to fair price, if I can just move quickly, I talked about Mr. Quintero and the court's pointing out that he swung for the stands and missed. The court pointed out that SolarCity was solvent, valuable, and never in danger of bankruptcy. It had assets of over $8.5 billion. It had liabilities of about $5.3 billion. It had a net worth of over $3.2 billion. The plaintiffs tried this case saying it was worthless. The court said if you just look at the accounting sheets, it's $3.2 billion. And KPMG, who had no connection to Tesla except to give an audit report with respect to the transaction, found that there was $89 million of asset value over and above the price. They found negative goodwill. I've been doing this kind of work for 40 years. I don't think I've ever seen a transaction with negative goodwill other than this one. There's always a goodwill plug in the balance sheet for the difference between what was paid and what the assets were worth. Here, KPMG found the opposite. The assets were more than they paid for them. How you can find that the company was insolvent in the face of that record is really incredible, in my view. And as I said, the court went through 20 pages of other grounds: market evidence, the shareholder approval, the DCFs that were done contemporaneously, the fairness opinion, the synergies. They didn't ever mention synergies. They said the board focused at the time on synergies. They were analyzed by Evercore at the time. They were disclosed to the stockholders at the time. The synergies were clear. They were creating an integrated energy company that could walk into a consumer's home and say, I'm going to give you a mechanism to draw power from the sun. I'm going to give you the ability to store that power in a battery hanging on the wall of your garage. I'm going to give you the ability to plug your car into that battery every night and run your entire home at the same time. Nobody had done that. To this day, nobody has done it. It's why the company's not valued as a car company, because it's not a car company. It's an integrated energy company. This transaction enabled them to do that. The court saw that, relied upon the evidence of synergies. They ignore the evidence of synergies. That was only one of the 7 different factors. And what the court also said, and this is at page 64 of the opinion, is this. SolarCity had 15,000 employees, $200 million a month in business, over $3 billion in future cash flows, over 300,000 customers, and net assets in excess of its market capitalization. I don't see how, on that basis, this court can find respectfully that the lower court's findings of fact with respect to the fairness of the price were so erroneous that they're not entitled to deference. The court below applied the most rigorous standard Delaware law permits.
Thank you very much.
Thank you.
Let me first touch on process. Again, I would stress that it is not the plaintiff's burden to prove that every aspect of the process was unfair. We discussed whether or not there was a finding of unfair dealing, and I would refer to pages 102 and 103 of the court's opinion, and we could debate as to whether or not that constitutes a finding of fair dealing. But what it does show is that the court did not apply the correct standard.
Mr. Henry, can I just ask you, was it acceptable for the court to view both process and price in a holistic manner?
Well, it's the Weinberger standard requires that there has to be proof of both fair dealing and fair price. And then you look at overall, was it entirely fair? I think the court needed to come to a conclusion as to whether there was unfair dealing. And what the court did, and I think pages 102 and 103 illustrate this, is the court basically changed the standard. He says, well, there were, Eli was involved more than he should have been. And he says, but he didn't push back. There were no threats, fits, or fights. That's not the standard. It's not, you have to prove that he was turning over chairs in the boardroom and making overt threats. He says, well, it's okay that Elon was involved because he didn't impede the board. Is that the standard for fair dealing? And then he at the end says, well, the Tesla board meaningfully vetted the acquisition. That's not the fair dealing standard. So essentially, the court makes up its own standards and puts burdens on the plaintiff. You have to prove that Musk coerced the board, that Musk prevented them from vetting the transaction. That's not the fair dealing standard. So whether or not he made a finding that there was fair dealing, if he did so, he did it under the wrong approach. The market price really doesn't get defended here. It was the only quantitative measure that the court cited. The idea that, and there's all this discussion about, well, this was known and that was known, but at page 23 of our reply brief, the documents that the trial court said showed SolarCity's decline was known to the market were all from after June 21, the date the court selected as the market price date. So while facts may have been known before the stockholder vote, they were not known as of the unaffected market date that the court relied on as the quantitative proof, and that's where the persuasive evidence is. And so if that falls, then the evidence isn't persuasive. And the other things that are cited, I talked about discounted cash flow, and we hear about contemporaneous DCF. Well, both experts testified that the DCF, as Evercore did it, overstated SolarCity's value because Evercore included expiring residential tax credit cash flows in the terminal period. Even Musk's expert acknowledged that that was wrong. But that's what the court below relies on while disregarding the DCF analyses of the experts. And by the way, Musk didn't present Evercore as its expert. It hired Mr. Fischel. And Mr. Fischel said, oh, no, the expiring residential tax credits shouldn't be in. And of course, the terminal calculation is often the biggest element of value. They mentioned the stockholder vote, but what was not disclosed, and it's difficult to find in the court's opinion because most of the disclosure stuff is in a series of footnotes, some of which we identified in our reply brief. But all of those relate to Musk's undisclosed involvement in the process. And the court relied on those in finding that Musk participated in the process to a degree he should not have. Well, the stockholders were entitled to the same information about these undisclosed involvements because a reasonable stockholder might also conclude that these were important because they showed Musk's heavy hand, which, as Thorpe said, they should have been negotiating without his domineering hand, but he was at board meetings and the court found that he could not help himself but to make his views known. The lack of an independent committee in this day is evidence of unfair dealing, particularly when the board cannot explain why it did not create a special committee, and that led to Musk's inappropriate involvement.
Was he asked during his deposition that question?
The court cites trial testimony of the directors and says, for reasons unexplained, there was no independent committee. And so after all these years where the court has instructed that this is very important, when you don't do it and you can't explain it, that is very heavy evidence of unfair dealing. Thank you.
Thank you very much, counsel, for the excellent arguments. We'll take the matter under advisement.
Please rise.